I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame. Listen, today we are jumping into compilation number 36, and tonight is another ladies' night, another compilation full of women sovereign citizens that we have aired here on the channel. Before I give you the rundown of all the judges, courtrooms that we will be in on this compilation, let me first say that there will be no commentary at the end of these proceedings, and also there will be chapters added just in case you would like to jump around. With that being said, here is the lineup. The first courtroom we're going to be in is going to be Judge Richard Hillman out of the state of Michigan. Second, we will be in the courtroom of Judge Tammi Hayward out of the state of Georgia. And last but not least, we will be in the courtroom of Judge E. and Grant out of the state of Georgia as well. With that being said, guys, I'm excited to jump into this latest compilation, as I know you are as well. So without further ado, guys, let's go ahead and jump into these proceedings.
Next matter is LVNV Funding LLC versus Ruth Conway, case number 244008GC. Is counsel here for the plaintiff?
Yes, Judge Hillman, Cezanne Barda.
Well, you're an attorney, sir?
Yes, sir.
Oh, okay. All right. I couldn't tell based on the way you're dressed. We do expect lawyers to wear ties and suits for court proceedings, Mr. Barda.
Yes, Your Honor. I completely apologize. There are two attorneys that handled our docket via Zoom today. Both failed to appear. I don't know why, and now I'm scrambling. I apologize.
Okay. All right. Is Ruth Conway present?
Yep.
Okay. Good afternoon. All right. So this is plaintiff's motion for summary disposition. Ms. Conway, the plaintiff filed a request to have a judgment granted in this matter. Mr. Barda, do you wish to proceed?
Yes, Your Honor. Our motion is based on MCR 2.116 C9 C10. We don't believe there's a genuine issue of material fact to move forward to trial. This is a straightforward collection matter whereby it was original creditor of Credit One Bank. LVNV purchased that, and all the chain of title and bill of sale documentation is attached to our motion. We also have billing statements showing charges made and payments made, which comports with the account stated theory in the state of Michigan. The address on those billing statement matches the same address where the proof of service went for this file. And we also have an affidavit from our client stating how much is owed at this time. Defendant not only failed to file a response to our motion for summary disposition, but also failed to file a counter affidavit, which is required by court rule. And even looking at her answer, all she states is she doesn't believe that this is her debt. I believe that plaintiff has provided proof and has established that this account was the defendant's, and I don't believe there's been there hasn't been a defense raised to be able to prevail at this time. Plaintiff respectfully requests that our motion for summary disposition be granted.
Okay. All right, Ms. Conway. So I have this motion for summary disposition that was filed by the plaintiff back on December 17th. I don't have any written response that was filed by you. I see you're holding up some kind of a receipt. I don't know what that's a receipt for, but we did receive your answer to the complaint. What date is on that receipt that you're holding up, ma'am?
October 29th.
Okay, so I think you're referring to your answer to the complaint that you filed in this matter, which was dated, let's see, which is dated October 28th. So I'm guessing that what you're holding up is verification that you filed an answer to the complaint. However, there was a motion for summary disposition. And basically
I
what
never got that. I
hang on,
never got that.
ma'am, hang on. You need to listen while the court's talking, and then I'll give you an opportunity to talk afterwards. So there was a motion for summary disposition. That's a request for a judgment, and it has an affidavit attached to it, and it has bills showing that you had a Credit One credit card and that you had made certain charges. It looks like there's charges to Meyer and Mason. There's charges to the city of Mason on the credit card, Dollar
Seriously.
Tree, and Celebration Cinema. And what the plaintiff has indicated is that that Credit One account was purchased by LVNV Funding, the plaintiff in this case, and that based on the fact that you had used the credit card and you had made payments on the credit card under Michigan law, that's a cause of action for account stated, and you would have an obligation to file an affidavit indicating that those were not your charges and you did not have an account with Credit One, and you've not filed that. Is there anything you would like to tell the court, ma'am? This is the time for you to make your response.
Okay, I'm making this statement. I am here under duress. I have formally put in a formal complaint to the Consumers Finance Protection Bureau. I don't know who LVNV Funding is. I have never heard of them in my entire life. This law firm has done nothing but harass me with document after document. I had 3 collection agencies approach me on this matter. I contacted the other 2, told them exactly the same thing I told this firm, but this firm has continued to harass me. I have made that formal complaint to the Consumers Finance Protection. Whether they protect me or a loaning institute is another story. I am here under duress. I live on Social Security. I will be 69 years old in the fall, and I do not have a job. I do not work. I have 14 grandchildren. I'm a mother of 5, and 2 of them are veterans of the United States military. I help with my 14 grandchildren. So I don't have a job. I will collect Social Security.
Okay, let me ask you this. Did you have a credit card at Credit One?
I do not ever recall having a credit card from any place. And especially, I would never have a credit card with a small amount of credit. In my past, whenever I had credit, it was a decent amount of money that I had on a credit card balance that I was allowed to borrow. That I get a phone call every other day. How do these people know I don't have Medicare B? How do they know that? I get harassed to buy Medicare B. I can't afford Medicare B. I live on Social Security. So how do I get them knowing I don't have it? You tell me.
Okay. All right. Anything further, Mr. Barta?
No, I would ask for our motion to be granted at this time, Your Honor.
Okay. All right. Well, Ms. Conway, we do have rules in lawsuits in terms of what's necessary to get past a summary disposition motion. You would have been required to file an affidavit verifying that you never had any credit card with Credit One, and that you were not the person that used this credit card that was in your name and made out to your address. And
Excuse me, but I was never asked. I was never asked by the court or received a document telling me I needed to do that. You're taking advantage of somebody that's not being represented by an attorney under maritime law. I'm representing myself under the power and the attorneys of Jesus Christ.
Okay. All right. Thank you, ma'am. So a summary disposition is granted for the plaintiff. And
I live on Social
Miss-
Security. I know federal law.
Ma'am, you need to stop talking while the court's talking. Mr. Barta, you can submit a judgment under the 7-day rule with the court. That's all for the record. Good luck, ma'am.
Thank you, Your Honor.
Good luck to you guys with Donald J. Trump. Maritime law is going bye-bye. You're going to have to all relearn constitutional law. Thanks to Mega and us Anons.
The next case is LaTanya Denise Turner versus Brian K. Widener, State of Georgia, Salah Holdings, Delphine Gresham, and Larry W. Johnson. All right, is there Ms. Turner, LaTanya Denise Turner?
Yes, I'm the attorney, in fact, on behalf of the principal, who is the resident agent. I have also already submitted forms appointing the judge over this matter to administrate on behalf of the principal. And I also submitted the rest of my entries on records. Now, with that being said, the Form 56 appointing judge.
Ms. Turner, I gotta see you first.
Okay. I'm trying to, there I go.
Okay, there you are. All right, so
Okay.
Ms. Turner, very quickly. I've reviewed the information that you provided. First of all, you're suing with respect to a foreclosure, which is a situation that involves land and a determination of ownership with respect to land. That is not my jurisdiction. I'm in state court. State court does not have jurisdiction over determinations of land. We deal with dispossessories, which is a temporary situation with respect to land, the allowing someone to use your land in exchange for rent or your property in exchange for rent. But we do not deal with the whether a foreclosure is proper. So in this case, this court is going to have to transfer your case to the Superior Court of Clayton County, depending on whether this is Clayton County that's involved. And so I see you're suing the state of Georgia. Not sure how they're involved. Not sure how any of these parties are really have an interest in this case. But with respect to the jurisdiction with for foreclosures, that is not what I do. Okay. All right. Is there anyone else here on behalf of any of the other parties who either disagree with what I've said or who have anything that they would like to put on the record?
So, Your Honor, this is Larry Johnson. I represent Brian Widener as well as myself. I just want to point out to the court, this was initially filed and I was not named.
Okay.
And after I filed an answer on behalf of Mr. Widener, the plaintiff just stuck my name and added it to it without a court order. And at that point in time, she needed a court order. So I'm not personally, I mean, I'm only in this case because I filed an answer for Mr. Widener.
Intended to name me too. So Ms. Turner, I know you have a set of beliefs about how the law works, but the way we do it here is just because somebody files on behalf of another person, everybody's entitled to have an attorney represent them. And so you can't then sue the attorney for giving them a defense. So everybody who comes into the case doesn't get sued individually. Like there are people who are responsible allegedly for what you are contending happened, but then there are other people who they choose to hire to help them navigate the case. For the people who are navigating the case and for the judges who are dealing with the case, you don't get to sue them because they don't have an interest in at that level. They're just trying to help the other person navigate the case, okay?
Could I get finished recording my interest on record?
No, ma'am. You've done that. You're the plaintiff.
Okay. Well, Judge, I would like to record my interest on record.
I'm not sure what that means, ma'am.
I'm the attorney of fact on behalf of the principal, who is the registered agent. I already submitted the Form 56 upon you over the matter to administration on behalf of our principal.
Ms. Turner, nobody gets to appoint me over the case. I'm already appointed to whatever's assigned to me through the clerk's office.
I appointed you through my for my trustee. And Your Honor, I would like to add also to the case and ask you a question.
No, ma'am.
Yes or no?
The question that I'm not going to answer any questions because this is not my jurisdiction. I'm going to transfer the case to Superior Court and let them sort it out because land use and land and interest in land is under the jurisdiction of the Superior Court. Okay, so we'll get you an order. We'll also dismiss Mr. Larry Johnson from the case pending whatever the Superior Court decides because he's only here to represent the defendant, which the defendant has a right to hire an attorney to represent them, and that attorney doesn't deserve to be sued because they are helping somebody defend themselves.
This case is also in the federal court also.
Okay, then if it's in federal court, then it probably doesn't need to be here also. You shouldn't have a case running in two different courts at the same time. Okay, that's just going to cause confusion. And you're not going to achieve what it is you wish to achieve.
Okay, Your Honor, I know this court has no jurisdiction per 12 CFR 1500. And also, is there or should there be an investment in private residential property in the United States? Or is deposit?
That is a question bigger than any of us can handle. People can invest in whatever they spend their money on. So at this point, I think that you're going a little bit too far afield. Like I said, we're going to go ahead and transfer this case to Superior Court, and my brother or sister judges on Superior Court will help you sort out what it is going on. Okay. All righty. So we'll go ahead and get an answer out to all of you. Get an order out to all of you transferring this case to Superior Court. But just as an aside, Miss Turner, everybody who comes in as a representative of somebody else, if they're an attorney, don't sue them because it just makes the case harder to get through. Okay, if you want to achieve something with respect to finding out what happened with your foreclosure, don't keep adding people to the
Your Honor, in this executive branch of law, I have a right to sue the attorney, anyone else involved.
Miss Turner,
in this executive branch, I do have a right to sue them and anyone else involved.
Is nonsense. None of what you're saying makes sense. None of what, Miss Turner,
it's federal law.
Miss Turner, we're not in federal court. None of what you're saying makes sense. You haven't established an estate. There's no trustee. You're giving us word salad. You're just saying stuff that you've read or somebody told you was appropriate. It's essentially called a sovereign citizen, but
no, it's not a sovereign. It's not. I'm not a sovereign citizen.
If those things work, don't put
everybody with you. Don't put that on me. I'm not a sovereign citizen.
Turner, you've made statements that sovereigns use, and so
I have my trust set up, and I'm not a sovereign citizen.
Yes, ma'am.
I am a person working in my trust.
Okay,
I'm not a sovereign citizen.
All right,
that's against the law.
Okay,
I'm not a sovereign citizen. So I have my trust set up.
Okay.
In a way that it's working for me, and I have it set up.
Okay.
And that's what I'm working on, my trust.
Miss Ellis, you could come into the camera for me.
I'm here by special appearance judge.
Hold on one second. So Miss Ellis, I just need to swear you in first, and then you can make your statement. If you could please raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I stand in honor and affirm that my words shall be truthful with full reservation of my rights under God's laws and natural law.
Okay, you can put your hand down now. Thank you. All right. So I have already reviewed the case. I remember Miss Ellis from previous dispossessory where there was, long story short, that the parties, at least at that time, did agree that she had taken subject to a valid lease. And that they had not pled for non-payment, and I'm assuming this is where this new dispossessory is based on the non-payment, based on the lease that she had with the previous owner. Is that correct, Mr. Thor?
That is correct, Your Honor.
Okay, and it looks like so, Ms. Ellis, I looked that you did file a late answer in this case. I saw that you had said you had emailed emailed your answer or some sort of response to the plaintiff, that does not count as an official answer. So it actually, your answer does have to be uploaded into the file within the 7-day time frame. So it is a late answer. I did also just reviewed. I didn't see any legal defenses or counterclaims in this. So this would technically today be a judgment on the pleadings. So Mr. Thorpe, if you'd like to present your case.
Yes, Your Honor. So this was filed for non-payment of rent. Service was affected on December 10th. No answer was filed. Defendant is in default. We request a immediate writ of possession.
Okay, with the judgment on the pleadings, it would be 7 days from today. So that would be the 5th of February. Since you, well,
That'll yeah.
It was a late answer. You are right.
May I, Judge?
Yeah, just 1 second. I'm just getting his case first, and then I'll come to you. Let's see. Yeah. Okay. So based on the answer being filed late, so you're just seeking the writ. You don't want the answer accepted, so you're just seeking the writ.
Correct, Your Honor.
Okay. Okay. So, Ms. Ellis, before you make your statement, I just want to make just a general statement about the fact about the answer being late. Okay. So here are the pros and cons. You filed a late answer. Like I said, there wasn't any legal defenses or counterclaims in the answer that you did file, but you did file a late answer. If you want me to accept that answer, that would subject you to being subject to a money judgment in the case. However, it would give you an additional 7 days before the plaintiff could file for a writ of possession. If your late answer, if you choose to have me not accept your late answer, then the writ would be available for them to apply for as early as today, but you would not be subject to any form of money judgment that they could use to collect on. But you would have to, the writ would be available to them a little bit 7 days earlier than it normally would have been. So I guess my first question, so I guess if you'd like to make your statement, but then I'm going to need to know whether or not you want me to accept your late answer, because if you want me to accept your late answer, there would probably be a money judgment associated with your order, but the writ would be applied for in 7 days. If you do not want me to accept your late answer, it would just be a writ available today or whenever they filed for it already, I believe. The writ would be signed today, but there would not be a money judgment against you. All right. So if you'd like to make your statement now.
So under what authority is the abatement that I filed could not be the answer? Because is it ethical for the court not to accept the abatement that I filed, because that's how I usually filed, and it was always never a problem?
There's nothing filed.
So I have that evidence because I went into the court and they showed me that was filed, and they said to me, that's what you were stating this court case on. So I want that answer to be put in place as the answer for that debate.
If you file the late answer, like I said, it would subject you to a money judgment. I'm not sure what you mean in terms of an abatement, but the rules for dispossessories are pretty simple. If you have not paid your rent, they will file based on non-payment of rent. They'll issue a demand. And then if you do, and essentially, unless you can show that you've got some sort of legal defense,
I do.
The itself, and what would that be?
I do have legal defense. First, I want to repent for all my debts, and I like to rescind my prior actions to start over. Evidence that I filed a case. I filed to buy the premises from the real party of interest. That's why I was asking this attorney if he does have evidence of who's the real party of interest on this property. Because even yesterday, I was speaking with the owner of the property, telling me that I need to send in a GAR and my proof of funds. So if this is not about possession or monetary value, because I have all that evidence.
So Ms. Ellis, in the previous case, it was shown that this plaintiff purchased the property at foreclosure. You had a lease with the former owner, and like I said, there's nothing along those lines. Hold on 1 second.
I do have that evidence, Judge, because we never get to that situation because of all the situations that were happening. I do have all that evidence.
Okay. Do you want me to accept it? Miss Ma'am, do you want me to accept your answer or no?
Yeah, I want you to accept my answer so I can move forward.
All right, I will accept your late answer. That does mean, Mr. Thorne, that the writ would be available in 7 days, but you can seek a money judgment. Ms. Ellis, you can make whatever argument. I've read through everything you filed in the case. It does not present any sort of legal defense to this dispossessory proceeding. All right, so Mr. Thorne, she does want her answer accepted. So if you'd like to present evidence on the rent owed, you can do that if you'd like.
I believe you have a copy of the lease agreement, Your Honor. Monthly rent is $23.50 with a $30 late fee. Rent has not been paid since October. It was found, I guess, in the prior case handled by the prior counsel that rent had been paid through September. So October, November, December, and January, and late fees would be $9,520.
Okay, you said it was $2,350 per month?
Correct.
And then that would be...
And a $30 late fee.
So you're not seeking... Okay, so you're just seeking through January?
Yes, Your Honor.
And may I ask a question, Judge, if that's okay?
Just 1 second. Just 1 second.
Okay,
Yeah.
thank you.
1, 2, 3, 4. Okay. So I did. So that's 4 months, October, November, December, and January at $23.50 per month, plus $120 and $30 late fees per month. That amount is $9,520. All right, Miss Ellis, what would you like to say?
So I just need to ask the question. So if the payment is not received while I'm negotiating with the owner to buy the property, you said in 7 days, what's the next step?
Well, they're not required to accept any if they choose to accept payment from you, that would cancel the writ in this case. So if you come to them and you guys are able to work something out and they agree to accept funds from you, that would cancel the writ of possession in this case. But again, that's something you'd have to reach out to Mr. Thorne to talk about. But again, like I said, if they did accept, the triggering thing is them accept. If they accept it, if they accept the funds, if you send in funds and they accept it, that would mean they would have to cancel the writ. But otherwise, the writ would be in place.
So what is being done today? You're filing a writ for possession in 7 days. Is that what you're doing?
Okay. The landlord will be able to, because I'm accepting your late answer per your request. The landlord is seeking a money judgment in the amount of $9,520. And then they will be able to apply for writ of possession by 11:59 p.m. on next Wednesday, which is the 5th of February.
So that will be a new case or the same case?
This is this case, ma'am. This is the order in this case.
So will I be back in court or not?
This case is going to be over as of today. This will be a final order in the case. I will enter that order, and then the writ will be available to them to apply for at 11:59 p.m. on the 5th of February.
So is this a default judgment that is going to be closing out today, you're saying?
This is not a default judgment. It's a judgment on the pleadings. You didn't present any legal defenses. I'm accepting your answer, but there are no legal defenses or counterclaims regarding this possessory. So they're going forward today just on the pleadings. Based on the pleadings, the amount owed is $9,520. And like I said, one more time, the writ will be available at 11:59 p.m. next Wednesday, which is February 5th.
Thank you.
All right. So that'll be the order of the court, Mr. Thorne. I will prepare that order. Okay.
Thank you, Your Honor. I appreciate it.
Thank you. Have a good day, sir. You're both free to go.
I'm not threatening you. Say one more word and that's 30 days. 30 days.